Delivery of judgment, item 1.
Appeal is dismissed.
I give you
Dismissed. You put a sign in. Delivers. Dismissed.
I beg to mention for listing of two IAs which have been filed in two separate criminal appeal. Already registered. I have been registered. So maybe listing of it.
When?
On Friday, 12/12.
Huh?
On Friday, next Friday. Friday.
Okay.
Obliged.
daily list for motion, item 1.
That notice be issued, my lord, regarding my lord remission policy adopted by the whether they have prepared or not by the various state of northeastern.
We will have to make the respondents. Who will be the respondent?
Respondent, my lord, your lordship kindly see. Yes, state of Assam represented by state of Assam, state of Nagaland, state of Mizoram, and state of Arunachal Pradesh. Because it is the duty of the state, my lord, as per the law.
Represented by the chief secretary.
Yes. Yeah, here, my lord, probably additional chief secretary is looking in. And home commissioner.
So represented by the chief secretary, home commissioners.
Yeah, already made party, my lord.
Where?
Already there, my lord. Phase 1.
They've already been made parties.
Yes, phase 1.
Okay, yes. State represent home. Okay, right. The present.
Probably Mizoram represent, my lord, probably.
Huh?
Probably Mizoram, I think.
The present writ petition.
So much, my lord.
The present so moto writ petition is for monitoring and supervising the implementation of
Remission policy.
remission and premature release policies of the states of Assam, Nagaland, Mizoram, and Arunachal Pradesh. In compliance with the order dated
25/4, my lord, and 4/11. There are two orders, my lord.
in compliance with the order dated
25/4/2025,
25/4
2025, and 4/11/2025.
and 4/11/2020.
Passed by the Supreme Court on, my lord.
Issued by the Supreme Court. In the case of
SMWP criminal number 4 of 2021. There are two cases, my lord.
in
In very first page, it is mentioned, my lord.
in SMWP bracket criminal number 4 of 2021
And special criminal number
and
5/29/21.
special criminal number 529/2020. Issue notice to the respondents, Ms.
P. Bhattacharya,
D. Bhattacharya, additional
AG.
AG, Mizoram,
3 and 7.
appears for respondents number 3 and 7. Who else? For this, for some?
Copies and PP logo.
Copy has not been served.
No.
Let notice be issued because
Huh?
that notice goes, my lord. I'll serve the copy, my lord, my High Court will serve the copy to my lord.
Right, issue notice, this, returnable in 2 weeks,
2 weeks, my lord.
2 weeks. The registry shall serve copies of the petition to the counsel for the respondent.
My lord.
The respondent shall obtain instructions at the next date, list the matter when.
From January, my lord, if 2 weeks, my lord, definitely holiday will come. So
Ah.
definitely first week of January.
If,
Seven.
Okay.
no, give on 5th January,
5th January.
5th January 2026.
Deeply above.
Into.
My lord, the petitioner advocate is on leave. I'm on his behalf.
The appellants. Okay,
The petitioner advocate is on leave. I'm on his behalf.
Petition? Huh? Appellant
Appellant-
advocate.
No, I oblige, sorry. As per instruction, kindly the matter be admitted and LCR be called.
You're for the wife,
I'm for the wife.
you're for the husband. Okay, right.
Please, solution. Is an appeal against order that
Right, Miss L. Devi. This appeal has been filed against the impugned order dated, judgment dated 27/9/22 passed by the Court of the Additional Sessions Judge cum Special Judge Pokso Sipsagar in Special Pokso Case number 31 of 2019 arising out of Simal Guri PS case number 12 of 2009, by which the appellant has been convicted under section 6 of the POCSO. Is the first time or is the IA, there was a
I
IA
was there, it was, delay was.
arising out of Jorhat PS case number 467 of 2019, by which the appellant has section 16 thing. And everything will be the same. Okay. So you're legally counsel.
Yes, my lord.
IA also same order.
Much obliged.
Item 6.
Right, this is a jail appeal against the impugned judgment dated 31/5/2025 passed by the Sessions Judge Golp in Sessions Case number 175 of 2018, by which the appellant has been convicted under section 302 and 459 IPC. With the appeal, call for the TCR. Mr. R. Kaushik appears for the state. This is the matter of the forum. Who do we have? Okay, Mr. Nabak Kumar Kalita Barwa is made, is appointed as a mic is closed. In the IA, you write Mr. R. Kalita, same thing. R. Kaushik, same thing, 4 weeks.
Item 7.
Item 7. With Mr. A. Hussain is, what is he? It's a, right, this is an appeal against the impugned judgment dated 29/5/2025 passed by the learned additional sessions judge Golagat in sessions case number 29 of 2020, by which the appellant has been convicted under section 5PC. Admit the appeal, call for the TCR. Mr. R. Kaushik appears for the state. This is the matter after 4.
Well, here, I don't know why it is showing special PP Assam. Perhaps
No, PPS.
PP Assam.
Mr. R. Kaushik appears for the state. That's all. This is the matter after 4. In the ISMP, correct. So as discussed, learned counsel for the. How come here? Why legal aid council 21C commercial quantity? These people have money.
They can afford.
They can afford more than 21C. Like,
Alright, here it is below commercial quantity.
no,
180
21C is the real quantity.
But recovery is 186 gram only.
186. Still, 186 is it's not a few pennies worth. It's quite a bit. 186. That means wrongly.
Yes, my lord. They have clubbed, my lord, from two persons, my lord. 186 gram each were recovered. So they have clubbed together.
Have clubbed together.
So 15 years punishment, since more than 3 years they are in jail.
Minimum is 10 years. Even for the middle quantity.
21B
This-
also.
Huh?
Even for 21B also.
Not 21B 10 years. So you've got another 7 years to go if you are found guilty. Right, Mr. S. Biswas, learned counsel for the appellant. Learned legal aid counsel for the appellant submits that though the appellant has been convicted, that appellants have been convicted under section 21C, the seizure made from each of the convicts, the alleged seizure made from each of the convicts was less than 200 grams each. Full stop. As such, section 21C does not lie. Full stop. The appeal has been filed against the impugned judgment dated 11/9/25 passed by the Special Judge Tinsukia in NDPS case number 45/T of 2022, by which the appellants have been convicted under section 29C, 21C and 29 and 29
Yes, my lord.
and 29 NDPS Act. Admit the appeal, call for the TCR. Mr. R. Kaushik appears for the state. The matter after 4 weeks. You're right, R. Kaushik 4 weeks. Huh?
But of like,
9 quarters.
May I please, Lordship. Paper books are received, Lordship. Matter may,
Received.
yes, Lordship, matter may be fixed for hearing, Your Lordship.
Okay, what about respondent number 2? No report.
Lordship, so notice is issued, notice to be issued. Lordship, I'll have to get the instruction. Last letter to parent.
2023.
Lordship,
What is their name?
S.A. Boruya, on behalf of Mr. S. Bortakur.
Which item are you talking about?
9, Lordship.
Item
Order.
9, Lordship.
9.
Yes.
Yes. Right. Have you received the paper book?
Objection
Lordship.
filed, Lordship.
Huh?
Objection filed.
Objection already.
That much do we know. Have you got the paper book?
Lordship.
Okay. Mr.
S.A. Boruya on behalf of S. Bortakur.
Borbuya appearing on behalf of Mr. S. Bortakur, learned counsel for the appellant, and Ms. A. Begum, APP, submit that they have received the paper book. Full stop. There is nothing to indicate that notice has been served upon the respondent number 2. As such, Ms. A. Sharma is appointed as the legal aid counsel for respondent number 2. registry to provide provide paper book to Miss Action. This is the matter after 2 weeks.
Lordship, matter maybe can be on 29th of January, Lordship.
Okay.
Deeply over, Lordships.
Doing better. One.
May please, ma'am. This I is from suspension of melody. Judgment and order, madam. Suspend of sentence, my lord.
Yes,
The I is for suspension of sentence, madam.
okay, so yes,
Yes. The
So-
while,
why should it be suspended?
my lord, here in this case, my lord, the ossification test was done of the victim. Ossification test says, my lord, it may be
Under section 4 and 8
Yes.
of the POCSO Act. Miss A. Begum, APP submits that she has got no objection to the delay being condoned.
Already delay has
Delay
been
condone,
converted
Lordship.
Delay condoned?
and notice has not been received. Respondent number 2.
No, it's not being condoned. Where is it condoned? It is this,
Oh, no, Your Honor.
no, it's not being condoned.
No, Your Honor.
Accordingly, the delay of 80 days condoned. Registry to this the appeal, I accordingly disposed.
Oh, no.
Notice was issued
Yes.
last time, it was not condoned. Third, Miss S. Khatania,
Yes.
learned counsel for the applicant who submit that there is a delay of 574 days in filing the appeal by which the appellant has been convicted. Applicant has been convicted under section 6 of the POCSO Act. Ms. A. Begum and the APP submits that she has got no objection. Same thing.
Please, your Lordship. In this matter,
So paper book has to be made.
30,
13 paper book has to be made, correct?
Lordship, we have served the notice to other party, Lordship. This appeal was admitted, your Lordship, by your Lordship on the last occasion. The
Right.
records are available.
Right, registry to prepare the paper book. List the map up for it.
Lordship, a time may be given in the first week of January, Lordship.
No, first thing, no.
First week, Lordship,
It has to be made. You would- And in the IA,
Lordship, a
that
date,
means,
date may be
become-
fixed, your Lordship.
additional PP is granted 4 weeks time to file an objection to the application under section 430.
Lordship, a copy of IA may be given to me because we don't have the fix.
I have already served to the Yeah.
Let's go ahead and
Will be made, paper book will be made.
16.
opt for objection. खाली IA चं टाकून just-
Can it be in the month of January, your Lordship?
Give a date and end of January.
January. Oblige, Lordship.
This is a melody. Mainly what I find, Lordship, from the records, he was convicted on the basis that he was found along with the deceased, Lordship. And it is alleged that he was holding an axe. That axe was not proved to be the weapon of a crime. That is there, Lordship. And second thing is that in 313, Lordship, he admitted those facts, Lordship, that he has committed the offense. And based on the statement under section 313, he is convicted in the present case.
313
313.
And his mother also have said that
cannot be the basis for.
That is the case. And he is.
He can be used for corroboration.
corroboration and moreover, Lordship, the weapon, Lordship, it was sent for FSL, which gave a positive test of human blood.
Correct.
X.
Says that it is
No,
not-
human blood, but it is the deceased blood or it is for other human, that is not true because for.
Whose blood is it?
Yes, that is not.
It is taken from the place of occurrence, Lordship.
This is what, you see, after.
And the medical also
They've got to
corroborates, Lordship.
improve, they've got to improve, that at least they should say it's the blood of the deceased or something.
Lordship, and moreover, it corroborates with the medical, Lordship, that the injury part.
That Lordship will get PW6, he says, Lord.
Extensive witnesses are there, Lordship. Mother is there, Lordship, who have admitted that he have killed because the son of the that is she have given 164, but she was not PW. But one of the nephew is the PW, but he also PW5 is the nephew, and 164
The appellant killed who?
His
One
friend.
of his friends.
they went for drink
They
liquor.
were, in
Drunk.
313, he said, Lordship, they were drinking together. Then the deceased cursed his mother. Therefore, out of anger, that incident occurred. That is what he said.
Sudden provocation.
Sudden provocation. That is what he said in the 313. But in fact, prosecution failed, but he admitted that that is the case. Lordship.
Okay, in his yeah.
Yes.
But then that will corroborate the evidence that he killed.
But other part of prosecution is not proved. The only incriminating fact is that the prosecution witnesses says that the axe was found in his hand. So whether that axe was used in committing the crime,
May
that
not be, but once he has said
But
that yes,
this is in his house.
no.
This is was also found in the house of the accused, Lordship.
it doesn't matter. When he says that he has killed, the weapon, if it's not found, what to do?
No, my submission for Lordship is that first prosecution has to prove their case. That 313 can be only for adding circumstance in the Lordship prosecution's case, Lordship. Firstly, that is my submission. Second thing is, Lordship, that apart from recovery of that axe, they have not proved any circumstances. And that too, Lordship, that the axe is the weapon of crime, that they have to prove first. That your Lordship is aware that Anjan Nath's case, Lordship, Honorable Supreme Court, arising out of our High Court, that held that mere recovery of blood-stained weapon will not do. It has to be proved that it is the weapon of crime. That has to be proved. So if that goes, only 313 remains.
But 313 will have
That
to.
313 cannot be the basis of your Lordship already, or I am also having some judgments Lordship, in that regard.
Yeah, but let us see. Let us see what the PW1 says.
Lordship.
And so PW1 says nothing.
Nothing.
So you had hidden yourself.
Yes, that is said. Lordship.
So this shows that you were guilty of some hiding some fact, and your 313 answer.
No, regarding
that you had killed.
No, regarding detaining part, Lordship will see that those are not in 161 statement, and even PW3 admitted in cross that he has not stated in his 161 statement. And others, Lordship, it is confirmed through IO, Lordship. Here in this case, he was.
PW5, Lordship.
Huh?
PW5, page number 15, Lordship.
Yes.
He is the maybe nephew of the, because accused is his father's brother, PW5. May I read that, Lordship?
Yes.
I know the informant and the victim of this case. The deceased Joypal Rava is my neighbor. One day about 2 years ago at about 6 p.m. I was present at home. At that time, on hearing the hue and cry of my grandmother, Apovala, I went to the house of the accused, where I found the deceased lying on the veranda of the house in a pool of blood, and the accused standing near the deceased behind, armed with an axe in his hand.
Armed.
Armed with an axe in his hand. I saw injuries in the head of the deceased. I realized that the accused has killed the victim. with that axe. I then snatched away the axe and from the hand of the accused and kept it aside. In the meantime, the villagers gathered there and detained the accused and informed the police. Later on, the police came and took away the accused. I had shown the axe to the police and they had taken so and so. Lordship, he don't have anything regarding his own father's brother, Lordship, accused. Nephew, because accused is his father's brother. And he have also said that the axe is in the hand of the accused.
Yes, PW5 evidence seems to be against you.
No, that is what I have already submitted before your lordship, that even if we assume that prosecution proves that I was holding that axe,
X.
so they have to prove that with that axe, the person deceased was killed.
You have corroborated with 313, Lordship.
Corroborated by your own statement under.
Statement 313. And it corroborated with medical.
Yes, we have corroborated.
No, there-
Heavy weapon.
Just I'm placing one judgment of coordinate bench, lordship, just one line. Lordship.
Corroborate.
Yeah.
Yes.
But what my submission is, lordship, that it is the
No, it depends on the facts and circumstances of each case. You see, the facts of that case might have been different from the facts of this case.
lordship.
Whether in that case that you're going to take before us, is there any evidence of any of the witnesses to the effect that the accused was seen with the axe near the dead body?
Lordship.
That might not be there.
PW5 have also stated in 164, Lordship.
No, in that case, lordship.
And 164, mother is also have
The
stated.
Hazarika's case, which lordship arising out of our High Court went to Supreme Court. In that case also, wife was found to be with knife in the same room. Husband died. In that context also, Supreme Court said that prosecution is bounded duty to prove that.
Agreed. But then was there any 313 statement admitting in that case? There was no admission.
No,
Here
here,
there is admission.
the 313 will come once they prove for their burden first.
No, they have proved their burden. You now the thing is that once your defense, when you take the defense that they have not proved, then okay, then again they have to now go into that issue. But you have proved that they don't need to go beyond that, beyond the recovery of that axe from you.
No, they at least the lordship for holding that axe would not lordship only give lordship suspicion, lordship, that he may be involved. But whether he is involved for
But
that.
once you have said, once you have admitted to the evidence, you have basically corroborated the evidence. That's all. I think. Once section 6.
Lordship, one more thing is that, Lordship, his mother, Lordship, Akobala Rabha. I don't know whether she is alive or not because at the time of 164, she was 77 years old. Lordship, may kindly peruse page 75, 164. My name, so and so. I was at home at the time of the incident. My son, Sosender and Joyful returned home after drinking liquor outside. On hearing a commotion, I went outside and saw Joyful lying in an injured condition. No one was there except Sosender. There was an axe at the place of the occurrence. I think that Sosender killed Joyful.
But this person was never made a witness.
I don't know, maybe she is already expired,
Could be.
77 years old.
We cannot. We cannot.
I just am saying for corroboration because
This, how can it be corroborated? Was it exhibited by anybody? Yeah. Was it exhibited?
Lordship, then Lordship, exhibit 2.
Huh?
Her grandson. He have
I don't know.
no. I'm saying that, Lordship. She was her grandmother.
Maybe.
PW5. He have also given this 164.
That's a different thing.
And
We are saying about this 164 statement made by this Akobala Rabha.
Akobala Rabha.
That is of no consequence.
But PW5.
To leave that. Give us the judgment.
In 2010, 12 SCC Lordship, paragraph 29 and 32.
2010,
12 SCC.
12 SCC,
Paragraph 29 and 32.
page.
Page 350. I have given the copy, Lordship.
The one you're giving us is 2002.
Yes, in 2002, 10 SCC, that is paragraph 27 and 30. Two judgments I have given. Okay?
I've got 2002.
Oh, Lordship, one.
You're giving only one. Okay.
Lordship is holding 2000.
I'm holding 2002, he's holding 2010.
I'm sorry, 2000.
Wait, is there some other one? Wait, there's another 2007 back. What is different? Let's be quick. Yeah, you're giving us only one copy.
I'm sorry, I have printed 2 copies, but
That is okay. And what is this?
this copy also I am relying. I will give another copy, Lordship. I am handing over the book, Lordship.
No, you give us that book copy.
Lordship.
So you'll have to read it with 32 and 33 also, huh?
Lordship.
Then what else?
Then 2002, 10 SCC,
Yes, para
27 and 30.
27 and 30.
Lordship.
27 and
GLT to Apache yourself.
Yes, then what else?
Lordship, one GLT, I will hand it over to your Lordship.
Yes.
I'm reading that
Yes.
paragraph, Lordship. I thought, Lordship, it will reach after break, Lordship. So I'm sorry.
No problem.
Secondly, there is no evidence that the blood stains found in the seized spear matched with the blood samples in the body of the deceased. The mere recovery of spear is not by itself any incriminating circumstance establishing a link between the accused appellant and the cause of death of the deceased, because the spear, as alleged, was smeared in blood, and yet no forensic examination of the spear and the blood stain has been conducted to ascertain whether the blood stains match the blood stain of the deceased. In the absence of any proof that blood stains in the spear matched with the blood sample of the deceased, it would be unsafe to rely on the proposition that the spear seized from the residence of the accused appellant was used in the killing of the deceased. There is also no evidence that the injury was caused by the said seized spear. So that is paragraph 22. I'm sorry, here also I'm having only one copy.
It's okay. And the prosecution side is without any citations, I guess. Oh, you've got.
No, Lordship, I will give Lordship. I will give it.
No, you don't have to if you don't want to.
Okay, Lordship.
Okay.
Because I'll have to charge Lordship because just that this file I have got now only and I thought that MS Bhuya will go through this file, but I have gone Lordship.
Yes. Okay, right.
Only thing that Lordship will see that even if he is admitted in 313 in his 313, whether that is true or not, that will be that can be only ascertained from the evidences laid by the prosecution, Lordship. So they fail to prove that this is the weapon of assault, Lordship. That must your Lordship will should
Beyond
consider.
reasonable doubt, Lordship, all.
Right.
Five.
Right.
Five.
No,
Fine.
holding the X, that I admit, but whether there the human
No,
blood,
like
but whether that is the same or not, that is missing, Lordship. So if they could have proved that this is the same, Lordship.
Okay, maybe that was not the weapon, but an axe was used.
But that Lordship remains to me, Lordship, but there has to.
No, the fact was that an axe was used. Maybe that axe
Lordship.
that was sent for FSL, that might not have been used, but the axe but an axe was used because he was seen with an axe.
But prosecution has,
These are all axe made.
but in circumstantial case, prosecution have to prove that beyond reasonable doubt.
Okay.
That part is, and he is already in custody for more than 6 years, or 6 years, 8 months. And even if you
This is
on the 313 part,
Huh.
then Lordship, probably that intention part is not there. Knowledge was there. So that also Lordship may consider.
Huh. Head.
But,
Right. Head Mr. A.M. Ahmed. A. Ahmed.
yeah,
Learned Amicus Curie. And Miss A. Begum. Learned APP. The appellant has put to challenge the impugned judgment dated 04/2020 passed by the Additional Session Judge Golpara in Sessions Case number 114 of 2019, by which the appellant has been convicted under Section 302 IPC for having killed his uncle, bracket father's brother, huh? Is it? No, no.
no, friend, Lordship.
By having killed his wife.
Friend.
Killed his, yeah.
Friend.
The problem is I'm mixing up with the other
That-
cases.
Friend.
For having killed his friend
The
with
full-
an axe.
Lordship.
Full stop. Mr. A. Mahmood, the learned counsel for the appellant submit that the learned trial court would not have convicted the appellant as it had not been proved that the act that had been seized by the police was the weapon used for committing the crime in question. He submits that though the axe had been seized by the police and the same sent to the FSR for forensic examination, there was no proof that the blood stain found on the axe belonged to that of the deceased. As such, there was no proof of the said weapon being the weapon used in the crime. In this respect, he has relied upon the judgment of the Supreme Court in the division bench judgment of this court in the case of Anil Nath versus State of Assam, 2018, 1 GLT 579.
And also, Lordship, that PWA, he also, that is the doctor who conducted postmortem. He also accepted that it is a fact that such injury may be caused if a tree falls on the head of a person.
If a tree falls.
Tree falls.
So the tree fell inside the veranda.
So that prosecution have to prove, Lordship.
Okay.
That is a
Right,
probable case
right.
which is there in.
The learned amicus curiae further submits that the evidence of the doctor was to the effect that, in his opinion, the injury on the head of the deceased could also have been caused by a tree falling on the head of the deceased. Anything else? That's all.
And that foundation of fact lies with the prosecution.
right. The learned counsel for the learned amicus curiae that submit that when the foundational facts have not been proved by the prosecution, regarding the appellant being the cause of the death of the deceased, the conviction was not sustainable. The conviction of the appellant under section 302 IPC was not sustainable. He also submits, one more thing, he also submits that the conviction of the appellant has been made on the basis of the explanation given by on the basis of the admission given by the appellant in his examination under section 313 CRPC. Wherein he admitted to killing the deceased with a knife, with the axe. He submits that he submits that in terms of the judgments of the Supreme Court in the case of Mohan Singh versus Prem Singh and another 2002 10 SCC 236, and in the case of Ashok Kumar versus State of Haryana 2010 12 SCC 350. The conviction of an accused cannot be based merely on the statement made by an accused under section 313 CRP, as it is not substantive evidence. Accordingly, submit that the impugned judgment should be set aside and the appellant should be acquitted of the charge under section 302 IPC.
An alternate prayer that may be also recorded.
The learned amicus curiae in the alternative phrase that
it may be converted to 304.
Phrase that as the evidence also indicates that a sudden quarrel had erupted between the two friends after drinking. The
intention part was not clear.
Intention of the appellant to kill was not made out. There could also have been no premeditation, as the friends had been drinking together a few moments prior to the crime being committed. As such, the appellant could at best be convicted under section 304 part 1.
Part 2. First part is regarding intention.
Part 2 IPC. Next paragraph. Ms. A. Begum, the learned APP, on the other hand, submits that the acts have been proved to be
There was also sporting was also sent for FSL. That also gave
weapon of the crime. Further, the
sporting.
whose t-shirt?
One t-shirt, one white
Who?
t-shirt, sporting with blood stain.
Belonging to whom?
That is not reflected, Lordship. Only this.
Don't say anything. Just
Lordship, it is exhibited, Lordship. Page number 91.
but please connect the dots. Don't expect,
Because the in
expect us to do your work.
no, Lordship,
You have got to,
no, Lordship, I'm sorry for that, Lordship. But the FSL Lordship gave for both the,
maybe, but please tell us, whose t-shirt?
Here it is.
Grandmother's t-shirt, grandfather's t-shirt, whose t-shirt?
Here it
Place
is,
of-
Lordship, here the dead body.
Yes,
Yeah,
the-
that it was.
The
The
t-shirt,
act-
the
the
t-shirt
t-shirt.
belong to whom? How, what relevance is it? Supposing it is found in in the floor also I mean, it is an admitted fact that he bled.
Lordship, and
So how does it, t-shirt, there's a blood stain on the t-shirt. I can understand if the t-shirt blood was the t-shirt of the, I mean, the t-shirt was the, belongs to
Deceased.
no, the appellant.
Lordship, then Lordship,
And if it can be said that the blood stain there was the blood stain of the deceased, then
Lordship, regarding the fall, Lordship, that it can be a happen through fall, but in the page number 83, Lordship, in PM report, Lordship, in the opinion of the medical officer, Lordship, in my opinion, the cause of death is due to coma as a result of antemortem head injury
that is
due
just
to a moderately heavy object.
madam, that is just a
Not-
suggestion given to,
Uh,
just suggestion.
Fall,
Naturally, if someone goes to the top of the tree,
Lordship.
30 feet or 40 feet tree, and takes a dive from there, as if there's a swimming pool down there, if he hits a head on the earth, naturally, he'll die.
So it's-
That's the
It's
suggestion.
opinion of the medical officer.
That's a suggestion. Now, what is the next? So one is the act.
X, then
Number
PW5,
PW5.
PW5.
Ah.
I've seen the accused with the X.
Okay. The learned APP further submits that the evidence of PW5, which has been corroborated by the explanation given by the appellant in his examination under section 313 CRPC, prove that the appellant had used the axe which was seized from him for hitting the head of the deceased.
Lordship.
As such, the conviction of the appellant had not been made only on the basis of the statement made by the appellant and in his examination under section 313 CRPC.
And it corroborates with the medical evidence that
So further, the medical evidence corroborates the evidence of the fact of the deceased having been hit with an axe.
Okay.
Anything else?
not.
Anything else? We have heard the learned counsel. Hearing concluded, judgment reserved. Okay.
Obliged.
Is Bunny. This is Bunny.
70.